You got hit with the DWI, and now you found out your BAC was over 0.15. Oh man, suddenly, you're not just facing standard charges, you're looking at enhanced penalties, a possible ignition interlock, and a lot more heat from the prosecutor. I'm Barrett Dye. I've fought these exact cases in Texas courts for years, and a high number on paper doesn't always mean a slam dunk conviction. This video breaks down what a 0.15 DWI really means, the defenses that still apply, and what you need to know right now to fight back and protect your record. Let's get right into it. If you're watching this, you or someone you care about probably either blew a 0.15 or higher on a breath or blood test in Texas, or you're worried about what happens if you do. You've heard it's a big deal, and you're right. In Texas, a DWI over 0.15 is what's called an enhanced DWI. This means the law treats you more harshly, with bigger penalties and more at stake. I want you to understand exactly what that means and what you can do next. First, let's talk about what you're up against. In Texas, a first-time regular DWI, meaning your BAC is under 0.15, is a Class B misdemeanor. That's serious, but a DWI with a BAC over 0.15 bumps your case up to a Class A misdemeanor. That's the same level as a repeat theft or an assault causing bodily injury. The maximum jail time doubles from 180 days to up to a year, and the maximum fine jumps from $2,000 to $4,000, and there are more mandatory costs that come with it. Even if this is your first DWI ever, a 0.15 or higher BAC means the court can treat you like a repeat offender. Judges and prosecutors in Texas usually see these cases as worse than a standard DWI. That means they often push for harsher penalties like more jail time, longer probation, or stricter conditions like alcohol monitoring devices or extra classes. Let me give you a real-world example. I had a client, let's call him Mark, and Mark was stopped after a night out. He cooperated, did all the field sobriety tests, and agreed to a breath test, thinking he'd be under the limit. Well, he blew a 0.16. Suddenly, what might have been a probation case became a fight for his freedom and his job. The prosecutor wanted jail time right out of the gate. And that's the reality you're facing with a 0.15 or higher in Texas. Here's the first thing you need to know. Just because the report says 0.15 or higher, that doesn't mean it's set in stone. These machines, whether it's the breathalyzer at the police station or a blood draw at the hospital, they're not perfect. They can be wrong. They can be off by a lot, and they can be challenged in court. For example, breath testing machines in Texas need to be calibrated and tested regularly. If the police department skips a step or uses a faulty machine, that number could be higher than what it really was. Blood tests can get contaminated if the sample isn't stored the right way or if the nurse doesn't use the right type of tube. In one case, the lab mixed up 2 blood samples and it took some digging to prove it, but it made all the difference. Some other common problems? Mouth alcohol. That's alcohol in your mouth, maybe from mouthwash or a burp, giving a higher reading. Or the officer waited too long to test you, so your BAC went up after you were already done driving. In Texas, the law says your BAC has to be over the legal limit at the time you were driving, not an hour later. You and your attorney can and should demand every piece of evidence. Look at how the test was done. Check the paperwork. Review the video. Sometimes the test result can be thrown out altogether. If that happens, the state's case gets a lot weaker. Let's talk about the fallout. If you're convicted of a DWI over 0.15 in Texas, the punishment doesn't end with jail and fines. It follows you for years. First, you'll have a permanent criminal record. Anyone who runs a background check, potential employers, landlords, even some universities, can see that you were convicted of a super DWI. Second, you'll have to install an ignition interlock device on your car as a condition of bond and, if convicted, as part of your probation. This is a breathalyzer that won't let your car start if it detects alcohol. You have to pay for it, usually about $80 to $100 a month, and it's embarrassing. If you drive for work, this can ruin your job prospects. Also, these machines seem to have consistent issues and problems that we have to defend frequently at bond violation and probation violation hearings. Third, your driver's license is automatically at risk. For a regular DWI, you might get your license suspended for 90 days to a year, but with the DWI over 0.15, the suspension can be longer, and getting an occupational license to drive for work or family might be a lot harder. Fourth, your car insurance rates, they're gonna skyrocket. Some companies will drop you completely, others will charge you hundreds of dollars more every month. Finally, It just feels different. Police, prosecutors, even judges treat you as more dangerous than someone just over the .08 limit. They might not be open to plea deals at all. They might want to make an example out of you. I had a client, let's call her Sarah. She worked as a nurse. After her .15 DWI, she was required by her professional board to attend special hearings, and it put her nursing license at risk. These are the kind of life-changing consequences people don't always realize until it's way too late. Here's the good news. A DWI over .15 is not an automatic conviction. Texas law requires the state to prove each and every part of the case beyond a reasonable doubt, including that your BAC was really over .15 at the time you were driving. Some defenses that come up often. Improper stop. Was there a valid reason for the police to pull you over in the first place? If not, everything after that might get thrown out. Then there's test issues, like we talked about. Machines break, samples get mixed up, procedures aren't followed. We can challenge all of that. Then there's medical conditions. Certain medical conditions like GERD, diabetes, or even certain diets can make you register higher on a breathalyzer. Of course, no proof of impairment. Just because the machine says .15 doesn't mean you were actually impaired while driving. Jury members care about how you looked and acted. That comes from body cam and dash cam video, and it can really help show that you weren't drunk at all. Let me share another client story. We'll call him James. Now, James was stopped after a collision through a fence, and the officer claimed he smelled alcohol. James didn't do any tests, but the officer secured a blood search warrant. Well, the blood test later came back at over .20. Really high. But we dug into the details and found out the officer didn't follow the right steps in working the DWI case. Plus, James' primary language was definitely not English. We dug through all the videos and laid out all the things the officer absolutely didn't even attempt to do in their investigation, but he should have. We secured an in-office meeting with the prosecutor and laid out how foolish the state was going to look at trial. And with that, we secured a dismissal for our client. No case is hopeless. The key is to act fast and get an experienced attorney on your side early. One of the biggest mistakes I see is people waiting too long to get help. In Texas, things start moving quickly after a DWI over .15. If you don't take action right away, you could lose important rights. You only have 15 days from your arrest to request a hearing about your driver's license. Miss that, and your license will be suspended automatically, even if you end up winning your case later. Evidence disappears quickly. Video footage can be deleted, witnesses' memories fade, and sometimes the police paperwork isn't turned in on time. Some courts move these enhanced cases onto a fast track for trial. That means you could be facing a jury much sooner than you think. If you hire a lawyer quickly, you give yourself the best shot at challenging the evidence, saving your license, and keeping your record clean. This is not the time to go it alone or pick a random lawyer off the internet. Fighting a DWI over .15 in Texas is a specialized battle. You want someone who's handled these cases before, who knows how to challenge the science, spot mistakes, and negotiate with the prosecutor. Ask any attorney you talk to the following questions. How long have you been handling these types of DWI cases? What's your strategy for challenging breath or blood results? Can you show me examples of cases you've won that were over .15? You want honesty, experience, and a clear plan. You need someone who will keep you informed, who will answer your questions, and who will actually fight for you, not just process your case. And remember, every case is unique. It's possible to beat a DWI over .15, get it reduced, or minimize the consequences. The sooner you get the right help, the more options you'll have. To wrap up, here's what you've learned. If you're facing a DWI over .15 in Texas, you're looking at steeper penalties, tougher judges, and more risk to your license, your job, and your future. But you're not powerless. The tests aren't always right. The system isn't perfect. With the right approach and the right attorney, you can fight back. But your next problem is right around the corner, your driver's license. You need to know how to keep it, or you could lose your right to drive before your case even makes it to court. That's why you must watch the next video, DWI License Suspension in Texas, the secret to keeping your license. I'll show you the critical step you have to take immediately within 15 days to save your license and what most people get wrong. Click over now. Protect your license, protect your freedom. See you over there.